finally, Lindy from Cancer Legal Line will be joining us talking to us about workplace and employment issues.
Hi, everyone. I'm Lindy Yokanovich. I'm the founder and executive director of Cancer Legal Line. And we provide and coordinate pro bono legal services to Minnesotans affected by cancer. So with Heather and Ann's talk tonight, now mine, we're going to hit the three big areas of questions that folks call in that they have needs surrounding, whether it's putting together some guardianship documents for their minor children, or figuring out why their SSDI application was denied, or if they have an employment question. So those are the types of things that we help with. There's absolutely no charge for our services, and we work very closely with attorneys throughout the Twin Cities who donate their services pro bono to our clients. I was moved to found Cancer Legal Line because there's just been a tremendous amount of cancer in my family. My mom's a 32-year colon cancer survivor. My cousin and best friend is a 10-year breast cancer survivor. Our grandmother died of breast cancer 6 years before I was born. My brother-in-law is a 2-time Hodgkin survivor. My uncle currently has bladder cancer, and my father-in-law has throat cancer. And almost all of those people that I love, along with some very dear friends who've had cancer, have really had a much more difficult time dealing with the ongoing, pervasive, crushing financial and legal issues that came about because of their diagnosis, even more so than the medical issues. And so that's what we do, is to try and help alleviate some of that stress. So there's brochures and some more information about our services out on the front desk there, and I'm happy to talk with any of you anytime that something might come up. But really, one of the biggest issues that comes up for folks is what am I going to do about work? I can't even begin to think how I'm going to manage all of this, all of my medical issues and work at the same time. So I put together a quick seven questions all through employment law that we'll get through in 20 minutes here, and just sort of know it's a global view of these issues, and that you can always call for more help. So the three big laws we're going to talk about today are the ADA, the American with Disabilities Act. It was recently amended, and it goes by the American with Disabilities Act Amendments Act, AHDAAA, the Minnesota Human Rights Act, and the Family Medical Leave Act. So just a quick little bit about what each one of those laws do. The ADA and its Amendment Act is a federal law that applies to every state in the same way, from Florida to Alaska. And you can think about the federal law as setting a floor, saying that we are going to say that these rights are guaranteed to folks no matter where they live, and this is sort of the base standard of what has to be provided to folks. In Minnesota, we also have the Minnesota Human Rights Act, which predated the federal law that was adopted in the 80s. And the Minnesota Human Rights Act says, well, you know what, the federal law is okay, but we're Minnesotans, we like to do things better and take care of people even more. So the state law can build up from that floor. They can put on a second floor, put on a turret, put a jacuzzi tub in the master bathroom. They can do whatever they want, as long as they don't dig a basement, as long as they don't take away any rights that are given by the federal law. Okay? And really, for our purposes tonight, the ADA and the Minnesota Human Rights Act, we'll just call it the ADA, and if there's a difference, I'll point that out. And then the third is the Family Medical Leave Act, the FMLA. That is a federal law, like the ADA, but with this law, in Minnesota, there's no additional protections that are given. So what the federal law says is what we get here in Minnesota. A few states have additional protections, like California, New York, and New Jersey, but Minnesota does not. Okay? So comparing these laws, the goal of the ADA and the Minnesota Human Rights Act is to keep people at work, to keep people working, even if they have a condition, a health condition, a disability. Now, when I'm talking about disability, I mean something vastly different than what Ann just talked about. And that's what's so confusing to folks, because people will call in and say, boy, I was denied Social Security disability, I guess the American with Disabilities Act doesn't apply to me. And nothing could really be further from the truth. For as stringent as Social Security is in finding this disabling condition and having everything spelled out and all these hoops you've got to jump through and conditions you must satisfy, it's really the complete opposite end of the spectrum when you're talking about the American with Disabilities Act. And we'll talk a little bit about just how broad that category is. But so please think of that word disability in a completely different context now than you just were with Ann. So again, the goal of the ADA, keep people working. How can we make it so that more people with a disability can stay engaged in the workplace and that they can be accommodated by their employer to stay working? And with the ADA and its laws, you're eligible for protection even before you get hired, even before you apply. It's really from the application to the interviewing to the hiring decisions, all of those types of decisions, all the way through to termination. People are protected by the American with Disabilities Act. Okay, and so the goals are twofold: to prevent discrimination and also to require employers to provide a reasonable accommodation. Okay. So now on the other side, the FMLA, its goal is to say, hey, we want you to be able to leave work. If you have a, call it a disability in the FMLA, they call it a serious health condition. If you've got a serious health condition, we want you to be able to leave work, take care of yourself, or take care of a loved one, your parent, a child, and know that your job is protected and that when you're ready to come back, your job will be here. Your benefits continue all the time you're out on leave as if you were still working. And but the catch here is that it doesn't apply right away when you're first hired. You have to work for a company that has at least 50 employees. You have to have worked for at least 12 months for that employer, and you have to have worked 1,250 hours within that immediate preceding 12 months. So there's a few more logistics to go through to be covered by that. But what you get from the FMLA, I'm just going to jump ahead here. I'll just finish that. So what you get with the FMLA is you get 12 weeks of unpaid time from work in a 12-month period. Okay, and we'll come back to that a little bit more. So how does the ADA and its companion laws protect folks with cancer in the workplace? Well, they prohibit discrimination based on disability. The federal law says if an employer has 15 employees or more, they're prohibited from discriminating against anybody based on disability. So very small employers under the federal law are not required to comply with those anti-discrimination pieces. But in Minnesota, that's not the case. The Minnesota Human Rights Act says it's one of those things where they've built up from the floor. They said that's not good enough. In Minnesota, no matter what, if you have one employee, you can't discriminate against them unless they're your relative. that's the one caveat, but that doesn't come up too much. So that's a little bit different where it's better to be in Minnesota because those protections apply there. Both laws also require an employer to reasonably accommodate a qualified individual with a disability who can perform the essential functions of the position with or without a reasonable accommodation. And like Ann, I put my lawyer quotes around everything that is a real legal term of art. So reasonably accommodate is a term of art. You'll see that term all over the place when you're talking about the ADA, and it has a very specific meaning. Essential functions, if you aren't trained in astrophysics, you can't claim that you've been discriminated against because you applied for a job as an astrophysicist and they didn't give it to you. So you've got to be able to do the essential functions of the job. But here, both the federal and the state law say that, because we're asking employers to actually do something more affirmative than just not discriminate, because we're asking them to accommodate somebody with a disability, we're going to give the really small shops a break and not require them to do that. So you have to have a minimum of 15 employees to require that there be a reasonable accommodation by the employer. Okay. Now, so under the Under the old American with Disabilities Act, before 2009, what had happened is even though the legislature passed the law, it was signed into law in the 80s, the way it was interpreted by the courts, it got sort of convoluted, twisted around, inside out, and upside down from what the original intent was. And what was happening is that folks who had a disability and needed to be under the protection of the law, they were not able to meet this huge, huge hurdle that the courts had put there for finding disability. So what had happened is the courts would say something like, oh, if somebody has diabetes, but they take insulin to control it, that's a mitigating measure. We're not going to consider them disabled. They're not going to be protected by the law. Somebody with cancer is taking some anti-nausea drugs to help them get through their chemotherapy. They're still able to work. They're not going to be deemed disabled because they're taking those anti-nausea drugs. So it really got turned around, and there was a big outcry. It took a long time for the law to get changed, but it finally did with the Amendments Act. So now, disability under the ADA is much easier to establish than ever before. And the legislature, in making these amendments, said, we really want everybody to know that we are making a seismic change in the law here. A lower standard is being used to find that there's a substantial limitation of a major life activity. Things are not listed out as a disability in this law as they are in Social Security. They use very general terms. So major life activity includes the operation of major bodily functions like normal cell growth. So they don't come out and say cancer, but they'll say if you have abnormal cell growth, you are deemed disabled. So they use this very sweeping language to cover a lot of different conditions. And then there's just, and then they're also the specific to cancer, they say even if you have a condition that's episodic or in remission, you are deemed disabled if it would have been disabling when it was in its active state. So even if you have a history of cancer and you're in remission, you're still going to be protected by this law, and you can't be discriminated against in the workplace because of that history of cancer if that condition would have rendered you disabled when it was active. Okay. So what is reasonable when asking for a reasonable accommodation? And this is where it gets really tough for employers and employees because it's an incredibly subjective standard, case by case. And the really important thing to realize as a survivor is that the reasonableness is viewed from the employer's standpoint. So it's not so much what the employee with a disability would like to have done, although that's taken into consideration. What's really key in determining is what is reasonable for any particular employer. So very common reasonable accommodations would be job restructuring, providing assistive devices, granting additional unpaid leave, shifting some tasks around. As long as you're still able to do the essential functions of your job and you just need a little help, whether it's a chair to sit on, some longer breaks, maybe going back part-time, those types of things are reasonable accommodations. And it's very important to know that half of them cost less than $500 to do, and a fifth of them cost nothing at all. The standards that the courts use to determine what's reasonable is that it's reasonable until it's unreasonable. So you can see why it's a moving target. But the reason why is because it depends on what the individual employee needs and the size of the employer and the resources of the employer. So here we have a grocery checker who needs to sit down during her shift instead of just standing the whole time. That's very most likely that it's a reasonable accommodation to provide a chair or a stool to sit on. Now, if in that same store, if somebody's stocking grocery shelves but they can't do all the lifting anymore, they might need some sort of reasonable accommodation to help them with their lifting. Well, if it's an essential function of the job and all they're doing is lifting, it might be too hard for the employer to completely restructure a lifting job and maybe find them another position to do in the store. Now, if you had twin sisters with the same exact diagnosis, same exact prognosis, same exact need for a reasonable accommodation, but one works for mom and pop little bakery and one works for, Nabisco, even though their needs are exactly the same and they're requesting the same exact accommodation, Nabisco is going to have to do a lot more accommodating because of the size and the resources and the other employees that are there to make up the work. So it really depends. So that's where that moving target comes in. Okay. What's really key to take away is that what is a reasonable accommodation has to be come at by an interactive process. As an employee, you just can't go to your employer and say, I have cancer, I need a reasonable accommodation, and just put it all on your employer to come up with the perfect plan for you. What works the best is when there's an interaction between employer and employee, and the employee can come to the employer and say, you know what, I'm going to need a little more time to rest during the day as I come back to work, but I thought about a few scenarios and I think this would work. Plan A, what if I plan on, taking an extra break after our rush at 9:30? And, coming up with some scenarios that you're showing that you're really taking into account the employer's needs and understand that you want to work with them to figure this out. It's really critical to think like a lawyer because a third party, a mediator or a judge is going to be looking at this, should it get to that stage, hopefully not, and say, what was reasonable here? And if you're the employee and come in with a whole list of things that you proposed and they were all shot down by the employer, it's going to be very telling in terms of reasonableness. So that's very important for you to keep in mind as you're thinking about all of this. Okay. So what protections does the Family Medical Leave Act provide? Again, this is job protected leave. 12 weeks within 12 months. It's unpaid leave. We get probably a call a week saying, my employer is not going to pay me for my FMLA. And the unfortunate part is that it's unpaid leave. But while the leave is unpaid, your benefits continue just as if you were working. So if your employer covers 75% of your medical insurance, they would still continue to do that. You do not need to go on COBRA when you're out on FMLA. It is not a COBRA qualifying event. You stay just as it was as if you were still working. Can you go back to this for a second? Okay. But although the leave is unpaid, you can, if you do have other paid leave, vacation pay, sick pay, paid time off, anything like that, you can take that at the same time. You can't necessarily string it along, so sometimes folks will call and say, I'm going to take all my vacation, then my PTO, then my sick time, and then I'm going to do FMLA. It's 12 weeks. So your employer can say, we're going to require you to take all this leave at the same time, and if you have 8 weeks of paid leave from another pot, that's fine. You can get paid for those first 8 weeks. But we're not going to extend it to 8 plus 12, okay? Very often, we'll have clients who call and say, I've been out for 12 weeks and my 12 weeks is coming up and I just can't go back to work. I need another 4 weeks, 8 weeks, another stretch of time off. And with the changes that were made to the Americans with Disabilities Act, that's really how these two work together, is that perhaps it'll be a reasonable accommodation for your employer to provide you additional time off from work, unpaid. And I think that's really important to be able to advocate for yourselves, knowing what the law is now, because even though, they're making an HR department, this is why employment lawyers are so busy all the time, is because mistakes are made every minute with regard to implementing these leaves. So if an HR person says, you better be back here on Monday because if you're not, your FMLA is over and you're done. That does not work anymore because of the huge changes that happened over on the ADA side. Before that, that probably would have been the case. Now, that's just not going to work. So, you know, you need to, you know, they need to be thinking, why would it not work for 4 more weeks if it already worked for 12 weeks? And how can we structure this so that, you know, we can come up with a good plan here? So, just because the 12 weeks are over, it's not necessarily the end of the line. You do have the ADA reasonable accommodation piece to fall back on. Okay. So, I'm interviewing for a job after my cancer diagnosis. Can I legally be asked about my health history during the interview? And it's a resounding no. No, no, no. No, everybody, no, you do not have to. Under both the federal and state laws, an employer is prohibited from asking medical questions unless and until a conditional job offer is made. So what that means here is that when you're first interviewing for a job, and you're being a good Minnesotan and you're thinking, should I tell them this, you know, why I did help, what should I say, what should I do? All you have to know is you don't have to tell them, and they cannot ask you. Do they ask you? Of course they do. Someone's got to keep the employment attorneys busy. They do. They do. Sometimes they may not mean to. I mean, there's a whole host of questions they can't ask. They can't ask about marital status. They can't ask about children. But they do. They're like, oh, didn't I see you with the soccer field? Oh, yeah. I mean, it doesn't have to be malicious, but it's important for you to know that those are prohibited questions, that they're not allowed to ask. Okay.
So then do you say to them, I'm sorry, you aren't supposed to ask me that, or?
Well, you know, and you can say, you know, oh gee, isn't that one of those prohibited questions under the, you know, and it does get a little tricky. Yeah, exactly. So permissible, they can say things like, in this job, employees are required to lift 10 to 20 pounds several times a day. Are you able to do this with or without a reasonable accommodation? And then you would say, yes, I can do that, or yes, I can type 60 words a minute, or whatever it is. What's not permissible is when they say something like, in this job, employees are required to lift between 10 and 20 pounds several times a day. Have you ever injured your back? The words "have you ever" should be sending out big, huge, you know, flares in your mind, because that's per se been found to be prohibited by the Minnesota Department of Human Rights. They cannot ask those types of questions. Okay. They can ask if you've met the qualifications for a particular job, if you're able to perform them with or without a reasonable accommodation. But they can only ask that if they ask that of everybody who's applying. Now, you're not going to know that, but that's the standard that's being set. Okay? So once they say, oh, Becky, we love you, we can't wait to hire you, but before we do that, we ask all of our employees to undergo a physical and drug testing and all these types of things. So after they've made this conditional job offer to you, now it's permissible. Now, this is where Minnesota comes running in on the white horse. But first, the federal law would say, you know what, at this point, we've protected you up to here, you're on your own. They can talk about your great-grandpa's bad back, they can ask you to submit, you know, all kinds of blood tests, everything. They can test, question, examine you for anything, okay? Minnesota says absolutely not in Minnesota, that any medical questions or examinations have to be specifically related to the job for which you're applying. So if you're applying for a customer service job, they can't give you the same exam that they're going to give the guy applying for the longshoreman's job, okay? It has to be related to the specific job for which you're applying, and even then, the have you ever, has anyone in your family questions are still not allowed, okay? So, that's our quick 20 minutes through all the employment issues. Yes?
I have one question that I think might be relevant for everyone. It sounded like under the ADA, anyone with an ovarian cancer diagnosis would be covered.
Right.
Is that correct?
Yep.
Whether they're in remission, their diagnosis was 13 years ago,
Right.
so everyone
Right.
with an ovarian cancer diagnosis would be covered by the ADA.
Right. You are a protected person with a disability in the workplace. The part that gets very hard now, and all of this is changing, I mean, in real time, because it never used to be that way. Even before the change in the law, I'd say, yeah, probably somebody with an ovarian cancer diagnosis would be, but now it's so broad that almost everybody is, because they've taken away the big issue about disability and said, you know what, we don't really care about that, we want to get to the discrimination part. We want to see what's happening and address the actions rather than focus exclusively on the disability piece, which is how it used to be. But what happens is that it has to be a known disability. So this is what comes up a lot, especially with men who call Cancer Legal Line that have prostate cancer. They don't want to tell anybody. They don't want to tell their employer that they're leaving every day for radiation, and that's why they're leaving. They're tired. I'm not going to tell them. I'm just going to keep working. And that's fine, but the problem is if their productivity is dropping, if there's, you know, there's issues with their performance, if the employer doesn't know that they're leaving because of a disabling condition or for treatment, they're going to think, boy, he's just slacking off, and, you know, we got to let him go. There's 100 other guys that want this job. It's too late for him to come back and say, hey, you're discriminating against me. So it has to be a known condition. Now, this doesn't mean you need to bring your medical records and have them, you know, out there in the lunchroom for everybody. But to say, you know what, I'm dealing with a health concern right now. I'm going to need some time off to deal with it. That's all that needs to be said. So, so yes, everybody with an ovarian cancer would be covered. But whether or not it's going to impact their ability to work, it really all depends on where they are in their treatment and recovery and remission. Okay? Yes.
I've got a question on FMLA. Do you have to take all of your paid time off, whether it be vacation time or whatever, first and then go to the FMLA? Or do you have the option of saying, well, I've been in the hospital for a week, so I want to take my FMLA there so I can still have some vacation time? Or how does that?
You know, the employer can require that you take both together. And when you think about it from the employer's standpoint, they want to capture every minute of time that they can under FMLA. So if it's a condition that's going to last 3 days or longer, is usually the standard that's used. So if you have a cold and you're out of 2 days, that's not going to be FMLA. But if you have bronchitis or pneumonia and you're out for a week and a half, that would be taken out of that FMLA pot. So it's up to the employer whether or not they're going to require you to take that, your vacation pay and things like that. That's up to the employer as how their policies are. But the way it usually comes up is that the employee doesn't want to, but the employer is making them take that at the same time with their FMLA. Okay. And I'll stick around as long as people have questions. Thank you.
Thanks, Lindy.